Welcome to International Trade Minute, Quick Fire Trade News, the essential podcast for today's trade professionals, presented to you by Rydell Law Firm. If you're a seasoned practitioner, this is where you'll find your weekly distilled briefing on the pulse of international commerce and regulation. We bring you the latest legal and trade news, distilled into straightforward, bite-sized updates for busy trade professionals. Sponsored by Rydell Law Firm, this podcast is crafted by expert trade attorneys to keep you ahead of the curve with concise, actionable insights. Perfect for your morning commute or coffee break. Stay informed without the fluff. Subscribe now on Apple Podcasts and Spotify, and join our professional community on LinkedIn. Today, we are exploring the complexities of export due diligence, a key classification ruling on pulse oximeters, new BIS guidance on contract clauses and rental addresses, expanded controls on Russian procurement entities, and upcoming compliance rules for investment advisors. We'll also cover recent fines for anti-boycott violations and a notable sanctions removal. Let's get started. Our opening segment, Anne van de Heetkamp, VP of Global Trade Intelligence at Descartes Systems Group, highlighted the increasing challenges companies face with export due diligence, particularly under the U.S. government's strict requirements for sales to foreign suppliers accused of illegal sales to Russia. These due diligence demands are proving especially burdensome for small and medium-sized businesses, with the process becoming so time-consuming and resource-intensive that many exporters are forced to abandon deals. The need to gather extensive information to ensure compliance with the Export Administration Regulations, EAR, is turning into a costly and complex task, often outweighing the benefits of the transaction. Earlier this year, the Bureau of Industry and Security, BIS, issued a list of 700 foreign suppliers potentially diverting products to Russia for military use, including missiles and drones. The July guidance requires U.S. companies to obtain affirmative information proving a listed party is no longer violating these restrictions before doing business with them. Anne van de Heetkamp pointed out that smaller businesses, already limited in resources, struggle to meet these stringent legal and compliance requirements. He compared this to the rigorous documentation needed for preferential tariff rates under free trade agreements, noting that both situations involve extensive verification that can outweigh the trade's potential benefits. Indeed, compliance challenges have intensified with new sanctions and export controls on Russia, placing even low-priority items like microelectronics and industrial inputs under scrutiny. While large corporations may manage these hurdles, smaller businesses, previously less focused on trade compliance, now face significant challenges. These include not only documentation, but also shipment tracking and diversion risk mitigation. As compliance becomes increasingly critical, businesses are investing in advanced tools and services. Van de Heetkamp highlighted Descartes' acquisition of OCR services, reflecting the industry's push to strengthen compliance capabilities amidst these complexities. From a practical standpoint, business owners must now carefully weigh the costs of compliance against potential profits. For many small to medium-sized enterprises, SMEs, if proving that goods won't end up in Russia becomes too burdensome, the deal may not be worthwhile. This situation may prompt SMEs to reassess their trade strategies, possibly focusing on less problematic markets or investing in compliance solutions. The heightened due diligence requirements have made trade compliance a critical part of international business. Anne van de Heetkamp emphasizes the need for SMEs to enhance their compliance efforts, potentially by seeking external expertise or adopting compliance automation tools. For trade professionals, the key takeaway is to anticipate and prepare for these elevated compliance expectations, blending legal insight with operational adjustments to remain competitive in global markets. Up next, Customs and Border Protection, CBP, recently reclassified LORT Technologies' pulse oximeters from China as medical instruments, overturning a previous decision that categorized them as tachometers. Initially, CBP classified the oximeters under tachometers due to their heart rate measurement function. However, after LORT Technologies filed a protest, CBP reviewed the classification and determined that pulse oximeters, primarily used to measure oxygen saturation in blood, are essential medical tools. Following a detailed review under the General Rules of Interpretation, GRI, CBP concluded that these devices should be classified under heading 9018, HTS-US, for medical instruments. Deloitte Technologies bolstered its case with FDA documentation certifying the oximeters as medical devices. While the FDA's classification isn't decisive for customs, CBP recognized that the oximeter's primary medical use aligns with the provisions for medical instruments. CBP determined that the device's diagnostic capabilities outweigh their rate measurement function, justifying their reclassification. This ruling impacts duty rates and compliance procedures, emphasizing the importance of thorough documentation in tariff classifications, especially for multifunctional devices. Importers of medical devices should ensure accurate documentation to prevent misclassification and delays. On our next story, last week, the Bureau of Industry and Security, BIS, issued new guidance to strengthen export controls, especially regarding sales contract clauses and the use of rental addresses for shipping and billing. The guidance focuses on preventing Russia-related violations. BIS highlights the importance of including export control clauses in contracts to reduce the risk of goods being diverted to unauthorized destinations, like Russia. However, BIS stresses that U.S. exporters must still secure the necessary licenses, as contractual clauses alone don't absolve them of their responsibilities under the Export Administration Regulations, EAR. BIS advises that while including export control clauses in contracts isn't mandatory, it offers sellers protection by ensuring foreign customers don't involve them in violations. Clauses should restrict re-export or transshipment of controlled items to Russia or Belarus without explicit permission. Hesitation from a foreign entity to agree to these terms should prompt further scrutiny. Regarding rented addresses, BIS warns against their misuse for unlawful shipments under the ER. Service providers offering these addresses must conduct thorough due diligence to avoid facilitating violations. BIS may enforce actions, including adding non-compliant addresses to the entity list, which carries specific licensing requirements. Additionally, BIS urges companies to screen both names and addresses of transaction parties against the U.S. government's consolidated screening list. Even minor address discrepancies should trigger thorough due diligence. The guidance includes scenarios where an address match should be suspicious. BIS also highlighted the importance of robust screening processes, especially concerning Russia-related sanctions and dual-use goods. Trade practitioners should adopt these practices to avoid potential compliance issues. BIS's guidance is a reminder that proactive compliance is essential in today's regulatory environment. Integrating these measures into routine checks can help prevent violations and ensure secure trade operations. Coming right up, the Bureau of Industry and Security, BIS, has tightened controls on third-country companies aiding Russia by expanding the Foreign Direct Product, FDP rule, and adding new export controls on CNC machine tool-related software, effective August 27th. The revised FDP rule allows BIS to target entities that indirectly send U.S.-controlled goods to Russia, aiming to dismantle Russia's procurement networks. Thea Kendler, Assistant Secretary for Export Administration, emphasized that these controls are crucial for cutting off Russia's supply chains. The rule now includes entities likely to divert controlled items to Russian or Belarusian defense sectors, marked with a footnote 3 inches on the entity list. For instance, this change allows BIS to target foreign companies sending U.S.-branded electronic components produced abroad to Russian firms linked to the defense sector. Previously, such restrictions applied only to designated military end users. Additionally, starting September 16th, new controls will require licenses for software updates for CNC machine tools in Russia or Belarus. These controls cover software for operating, setting up, and monitoring CNC tools, aiming to cut off support to Russian and Belarusian industries. Exceptions exist for software used in agriculture or medical sectors, but the tightened controls are expected to increase license applications by about 20 per year. These recent measures underscore the ongoing commitment to strengthen trade compliance and prevent the circumvention of export controls, ultimately enhancing the U.S.'s strategic leverage. For trade practitioners, staying abreast of these updates is essential, not just for compliance, but also for strategic planning and risk mitigation in international trade operations. Let's move on to our next segment. The Treasury Department has introduced new compliance rules for investment advisors, effective January 1st, 2026, to strengthen anti-money laundering, AML, and counterterrorism financing, CFT efforts. These rules close loopholes that have allowed criminals to exploit the U.S. financial system by investing illicit funds. Investment advisors will now be classified as financial institutions under the Bank Secrecy Act, requiring them to establish risk-based AML-CFT programs, file suspicious activity reports, and maintain detailed records. Additionally, a new FinCEN rule, effective December 1st, 2025, targets high-risk real estate transactions, mandating certain transfers be reported to combat illicit finance. Treasury Secretary Janet Yellen emphasized these measures as crucial to preventing criminal exploitation of the U.S. financial and real estate sectors. Investigations revealed that sanctioned entities, particularly from China and Russia, have exploited the investment advisor industry to access the U.S. financial system and sensitive technology. The new rule, which refines earlier proposals based on public feedback, tightens controls while excluding certain mid-sized and foreign advisors from the definition of investment advisor. The rule now focuses on advisors with U.S. activities or clients, but drops the requirement for AML-CFT programs to be U.S.-based, a change appreciated by foreign advisors. These measures aim to prevent illicit actors from exploiting U.S. financial and technological assets. FinCEN has given investment advisors a 3-year window to comply with the new regulations, recognizing the new technological and contractual burdens these may impose. Some advisors may need to develop new systems and revise contracts with banks and broker-dealers to share compliance responsibilities effectively. This regulatory update seeks to level the playing field within the U.S. financial industry, enhance transparency and integrity, and provide valuable information to law enforcement and national security agencies. Closing these regulatory gaps is expected to restrict Russian oligarchs and other sanctioned entities from accessing the financial lifeline they've historically relied on, thus enhancing the U.S.'s ability to counteract financial crimes and national security threats. For our concluding piece, Streamlight Inc., a Pennsylvania-based portable lighting manufacturer, has been fined $44,750 by the Bureau of Industry and Security, BIS, for violating anti-boycott provisions under the Export Administration Regulations, EAR. The violation occurred when Streamlight certified that its products were not of Israeli origin for a 2019 trade show in Bahrain, breaching EAR rules against supporting unsanctioned foreign boycotts. Streamlight voluntarily disclosed the violations, admitted to 3 breaches, including failing to report the boycott request, and must pay the fine within 30 days. Matthew Axelrod of BIS emphasized the importance of refusing and reporting such requests to avoid penalties. This case highlights the need for strict compliance with anti-boycott regulations and follows similar actions against Airbus DS Government Solutions and Wabtec earlier this year. Ilya Borisovich Brodsky, former deputy chairman of Russia's PJSC Sovcombank, has been removed from the Office of Foreign Assets Control's specially designated nationals list. This follows Brodsky's lawsuit against the State Department, citing undue delays in processing his delisting request submitted over 2 years ago. Brodsky was originally sanctioned in March 2022 due to his leadership at Sovcombank, Russia's third-largest private financial institution at the time. After resigning and distancing himself from Russian state entities, Brodsky sought delisting, but his request took nearly a year and a half to process, leading to his legal action. Brodsky's complaint highlighted the significant financial and personal hardships caused by his prolonged sanctioned status, including European banks denying his family members the ability to open accounts and restricted access to his funds in non-U.S. financial institutions. His successful delisting underscores the complexities and delays often involved in sanctions and delisting petitions. This case serves as a reminder for trade practitioners to be vigilant and proactive in defending clients' rights. Brodsky's experience could influence future delisting processes, potentially leading to more streamlined and transparent handling of such petitions. Thanks for tuning in to International Trade Minute, Quickfire Trade News, brought to you by Rydell Law Firm. We hope you found today's episode insightful and useful for your practice. Remember, staying informed is key to navigating the complexities of international trade. Don't miss our next episode. Subscribe now on Apple Podcasts and Spotify to get the latest updates right on your feed. Stay connected with our professional community and continue the conversation with us on LinkedIn. Until next time, stay informed and stay ahead.